Good afternoon again. Thank you so much for your time. Thank you for your attention today. Thank you for coming back after the weekend. Appreciate that. What you heard today echoed from several people about the person that Johnathan Quiles was and has been to his family. You didn't just hear today about the type of person that he has been. You heard about it throughout the last couple of weeks as well. And something that was said today a couple of times is that something redeemable there with Johnathan Quiles. You've heard about the aggravating factors from the state. I'm going to go through a few of those with you. Not all of them. Some of them we're not going to make any strong arguments to. I'm not going to insult your intelligence, as Mr. Skinner said. IS's unborn child was obviously less than 12 years. I'm not going to stand here and argue about that. But I do want to go through some of those because what you must do for each of those aggravating factors is you must unanimously find that each has been proven beyond and to the exclusion of every reasonable doubt. So I just want to bring to your attention a few things that we believe the state has failed to prove. As we talk about prior or previously convicted, we're talking about the crimes that you all just found him guilty of. We're not talking about some extensive or prior criminal history before this. We're talking about these crimes here today and only these crimes that you all found him guilty of. There's nothing previously from that. The second factor that they talked to you about had to do with the purpose of avoiding or preventing a lawful arrest. And I ask you, has that been proven beyond and to the exclusion of every reasonable doubt? That was the purpose behind what you have found him guilty of doing? If you do not feel that that is the case, if there's any doubt to that, any reasonable doubt to that for you, that is not an aggravating factor that you can put into that pile and start weighing, as Mr. Skinner used that analogy several times. The comments that were made later on are being used to inform about maybe what his mindset was at that time. But there's reasonable doubt as to those comments, what the truthfulness of those really were. I want to move on to the heinous, atrocious, and cruel, HAC as we sometimes call it. And it's kind of coupled with the cold, calculated, and premeditated aggravating factor as well. It's hard to have both. Can't have it both ways. And by that I mean, you can't say, oh, I couldn't stomach strangulating someone. And it's cold and calculated. You can't say that that at the same time goes in the same bucket. Those contradict each other, and the facts and the things that you all found, the testimony and the things that you heard on the wire, contradict some of this. So I want to go through a few things with you. On the wire, the thing that you heard was him confessing to shooting IS. That's what you heard. He never once in that wire talked about strangulation. A shooting death generally is not included in that heinous, atrocious, and cruel aggravating factor category. Doesn't mean that shooting death is not a terrible thing, so don't get me wrong. That's not typically what they're talking about. We're talking about something worse than that. Something where that victim was in a torturous type of circumstance. And a shooting death is typically not that type. The thing that you heard is actually from Damian Hatch. That's the person who said that there was a strangulation and he couldn't stomach it. And that testimony, we believe, has been proven to not be the truth. So if you're thinking back to what was said and what was brought up, I would stress to you all to think back to that testimony and what you actually heard. Reasonable doubt exists as to that aggravating factor. You talk about the statement of couldn't stomach it. That's not conscienceless. That means there was some conscience there. There was something there that said, that's not right. I can't do that. And it's such a crazy thing to stand up here and argue and talk about strangulation versus shooting death, which one was worser, and that type of which one's worse or not. Such a strange thing to stand up here and say. But the strangulation part is the part that would rise this particular crime to the level of heinous, atrocious, or cruel. So when you're thinking through that, if there's doubt there, if there's reasonable doubt there, that is not an aggravating factor that you can bring on to that next section. We're not arguing that there isn't at least one. I'm not making that argument. So when I'm talking to you about these factors, it has to go to what you're weighing in the end as you learn or think about these aggravating factors versus those mitigating circumstances. Let me talk to you about the CCP, cold, calculated, and premeditated. Cold, calculated, and premeditated. As French told you in her opening, that's the one they have to prove all of those. It's not or. You must be convinced beyond a reasonable doubt that each of those existed. And what we submit to you provides reasonable doubt for that particular factor. What did you hear from his brother? His brother told you that he called him in a panic, that he called him frantically, not knowing what to do. This is the day that this murder is alleged to have happened. That's not evidence of a months-long plan. That's someone who didn't know what they were doing. And specifically for the cold, that particular definition that you're going to be read from the judge talks about cool and calm reflection. And specifically, it's not an act that's prompted by emotional frenzy, panic, or fit of rage. We would submit to you that the evidence you've heard is that he was in a panic, that he was frenzied. That negates the cold portion of that aggravating factor. And if you don't have each of those, you cannot bring that aggravating factor into your weighing process. The sixth one, the fifth one has to do with the unborn child being less than 12. So I'm not going to talk about that one. The sixth factor that they talk to you about has to do with being in the familial or custodial relationship. You've already found that Mr. Quiles was in a familial or custodial relationship as it relates to IS. That was found within your sexual battery finding. I'm not arguing that. What hasn't been found, nor has it been proven beyond a reasonable doubt, beyond and to the exclusion of every reasonable doubt, is that he was the father of IS's unborn child. He didn't even know. If you take every word that he said it was a possibility, but he didn't even know that. So has that been proven, that he's in a familial or custodial authority over the unborn child? If there's doubt to that, which I would submit to you, that will be doubt, then you can't bring that into your weighing as it relates to the unborn child. Mr. Skinner talked to you a lot about being held accountable for your actions. want you to think back to jury selection. Seems like a lifetime ago. It's 2 whole weeks ago. 2 weeks ago we started. I asked each and every one of you if you believed that life without the possibility of parole, in the worst case you could imagine, if that was a sufficient punishment. I asked each and every one of you that. You all agreed to that you did believe that life without the possibility of parole was a sufficient punishment in the worst of cases that you could possibly think of. So when we talk about fully or partially accountable, life without possibility of parole is being held accountable fully for your actions. There's no partial there. I asked you during jury selection if you'd be able to meaningfully consider the mitigating circumstances that will be presented to you. I told you that those mitigating circumstances could come from anything. It could be something that we presented like we did today, witnesses that you heard from. It could be something that you heard throughout the trial. It could even be something that the state has said. It could be anything that you've heard, anything that you've observed. If you recall, when we were talking about those mitigating circumstances, I told you all that it was a very individual assessment, a moral judgment by each of you that you would have to make as to each mitigating circumstance that you find any weight to. And we have to prove those to you by a greater weight of the evidence, and I would submit to you that we've done that for each of the mitigating circumstances that I'm going to go through with you all. I want to talk to you about some of the things that we didn't present here today and just remind you of them from what you heard throughout the trial. You heard from Johnathan Lindros, and you heard from Gary Lindros. They talked to you about the type of worker, type of employee that Mr. Quiles was during his time with them. He wasn't with them for very long, only a few months. But he excelled. He did his job well. They said he did his excellence. He went above and beyond. He was a model employee. That has been proven by a greater weight of the evidence. You've heard that from multiple people. You've heard several other witnesses say the same thing about him. Not just in his as an employee, but just in general of how he is and the type of person that he's always been. He's a hard worker. He's someone who will go out of his way to help people. You heard anecdotal evidence of him building stuff at church, a sound booth, or the band area. You heard other people talk about him helping them out with several projects and things like that around the house, coming up with things. If he didn't know how to do it, he'd figure out how to do it to help out. But that was the type of person he always has been. You heard from Ulysses Dixon. He was the gentleman who came in, who led the Bible study. He told you about the things that he's observed of Mr. Quiles since he's been incarcerated for these last almost 5 years. He talked about how I think he said he clipped toenails for some of the elderly, that he helps out other people. You heard that echoed by Dr. Rohrer today. That's been reported by several people, that he was helping the elderly, helping those who are more vulnerable. The other things that you've heard about his background since he's been incarcerated, that he's been a model inmate. He's got no disciplinary reports whatsoever in nearly 5 years. And not only that, Dr. Rohrer told you that she was shocked to find out, surprised to learn, that he was allowed to be an alternate trustee, to go and clean the jail, and did that to excellence. He didn't have any issues, was entrusted with that. Why is that so important? Why would we be bringing that up to you? Why is clipping toenails for the elderly something that you would care about? because it demonstrates that there's something redeemable there. There's something good that he could still do, even after what you all have found him guilty of doing. There's something that's worth saving. You all get to decide what weight to assign to each mitigating factor that I'm about to go through with you. That's a decision for each of you to do. Each of you get to decide how much weight. We don't get to tell you that. We don't get to tell you that if you stack these up, there's no way they could overcome it. Only you can decide that. It's an individual decision that each of you have to make. Now, collectively, you all do need to find unanimously that each aggravating factor has been proven beyond a reasonable doubt. When it comes time to making that weighing, that's to you. That's to each of you. And the other thing I talked to you all about during jury selection, which is so critically important, was that individual decision and that individual moral assessment that each of you are going to make. We asked you all to treat each other with respect. We asked if you all would all agree to respect the decisions of your fellow jurors, and especially if they happen to disagree with your individual assessment. This is what we were talking about. That's the weight that we've put on you all. That's the job that you've been tasked with. So we're asking you to do that. We're asking you to look to each of those mitigating circumstances and weigh them against the aggravating factors that you find beyond a reasonable doubt. You heard from Mr. Quiles' family members and friends as well. You heard from a neighbor, someone who he worked on cars with, someone who he just happened upon. You heard him talk about the type of help he provided to him. Mr. Hale, Curtis Hale, gave you that information. You heard from a best friend of his aunt who was kind of like his mom. You heard the encouragement that he was to her during hard times. You heard from nieces. You've heard from cousins, nephews. You've heard from someone who was just like his mom, stepped in after his mom passed, became that aunt/mom, as she would describe. You heard her talk to you, and several of them talk to you about their love for Mr. Quiles. They've been here. They know the outcome. They know your verdict. And they were still willing to come here and testify to their support for a family member. To ask you to consider that when you're weighing these most important factors and circumstances. They asked you to save Mr. Quiles' life. Now, you're the trier of fact. We've been saying this from the beginning. You're the ones who get to decide, moving forward, what will be the recommendation. Let me talk to you about one last thing. We brought this up during jury selection as well. Actually, hold on one second. Let me grab something. All right. Just want to go through these mitigating factors a little bit more in detail, and then I'll wrap up with the last thing. One of the first mitigating circumstances that you're going to hear read from the court when you're read those instructions shortly will be that Mr. Quiles has no significant criminal history. uncontroverted. No one has said that. That has not been disputed. That we have proven by a greater weight of the evidence. He doesn't have a criminal history outside of what you all have found him guilty of. He was 33 at the time of the crime. You've heard that he was raised by his mother. You've heard about his father being absent from his life and the effect that that had on him. You've heard about the loss of his mother and the effect that had on him as well. You've heard about their special bond, their relationship, and how that bond has transferred over to his aunt. You've heard about from his aunt how she sees her sister through her nephew/son. You also heard about some of the challenges that he had. You heard about him using marijuana and alcohol and that being something that was normative, meaning maybe that's just the culture of the family and the effects that that has had on him as well. Dr. Rohr talked to you a little bit about, very briefly, but she talked to you a little bit about him suffering some abuse growing up. You heard from his aunt about some conflictual relationships that he's had with his brother, and that being a very difficult relationship. You also heard about his education. He dropped out of school in the 7th grade, didn't complete the 7th grade. He's self-taught, but for the most part, that was it as far as schooling goes. He did that because he became a father very young, at just 15 years old. 15 years old, he left school, started working. He's worked ever since, supports his kids. You heard that he has and has had a good relationship with those kids. He's got five children. 5 children that he still maintains relationship with. You heard about the area that he grew up in. Even growing up in a high crime, poverty-stricken area in Brooklyn, New York, you still heard that he stayed out of trouble. He at one point went into a drug rehab facility to get away, according to him. Get away from what was going on around him. You also heard from Dr. Rohr about personality disorder, what that means for his relationships, what that means for him acting on impulse, doing things without thinking things through. He doesn't have any sort of severe mental illness. He's of average intelligence, which I would say is probably higher than what you would think of someone with that, with a less than a 7th grade education. He doesn't have any known neuropsychological issues or anything along those lines. Pretty average in general. No cognitive deficits or anything along those lines that you have to consider. But he did have a bit of a dysfunctional background, dysfunctional upbringing. Now, just to kind of go through, and I've gone through a lot of the other ones already, just to kind of go through that last thing, I talked to you guys about this during jury selection. If you can recall what I said to you, I told you all that you may get to this point. We talked about the process that you all have to go through. There has to be at least one aggravating factor. If you find one aggravating factor, then you move on to the next step. That next step, where we kind of do this weighing, and I'm skipping some of it, but you're going to do that weighing process. You found mitigating factors. I believe there are mitigating factors that have been proven by a greater weight of the evidence that you have. There's going to be aggravating factors that have been proven beyond a reasonable doubt. We're not disputing that by any means. When you go back and you do that weighing process, even if you find that those aggravating factors outweigh the mitigating circumstances that we've presented, that you've heard, that you've observed, that you believe, that you, in your individual assessment, determined to be true, even if then you find that those aggravating factors outweigh, life is still an option. You all still have the ability, even after all of that, to say life without the possibility of parole is the appropriate punishment here. And I'm sure you remember, we went through this painstakingly because I asked so many of you that question. I asked so many of you, if even after weighing, and even if you find that this is the worst case scenario, even if you find that those aggravating factors significantly outweigh, life is still an option. There's something redeemable here. There's something here that you can latch onto and say life without the possibility of parole is what's appropriate in this circumstance. And that's what we're asking you to do. We're asking you to save his life. Does he deserve it? You probably don't think so. But is there something there worth saving? Is there something there that would make you all come back and say life without the possibility of parole is appropriate? It is a sufficient punishment. That's not letting somebody off. That's not letting accountability go by. That's holding someone accountable. That's making sure that this person does not have the possibility of ever doing anything like this again. So we would ask you today, as you go back, as you look at everything, when you come to that final decision within yourself of what is the right thing to do in this case, remember that life is still an option. And we ask that you would come back with that recommendation of life without the possibility of parole. Thank you.